It is already 11.
Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Good morning to all. Today's webinar topic is, this is the series of SEBI LODR. As we know, it's a master class and there's a 7th class for that. Reclassification as promoter, public and special rights to shareholders under Regulation 31, 30A, 31A and 32. And as usual, we have our esteemed panelists today, Dr. J. Sridhar, former president, vice president of Bajaj, company secretary and vice president of Bajaj, and I must say past president of ICSI. Welcome, Mr. Sridhar. Thanks for your time. And friends,
thank you so much.
Thanks. This second time, thanks for your time and agreeing to sharing your knowledge. To briefly introduce Mr. Sridhar. Mr. Sridhar is a fellow member of Institute of Chartered Accountants of India and ICSI. He is an alumnus of IIM Ahmedabad in Senior Executive Development Program and has done his PhD from Savitribai Phule Pune University in financial management in the subject of CSR. He has a rich post-qualification experience of 46 years in finance, taxation, secretarial and legal functions, including over 44 years in the Bajaj Group itself. Oh, great. He was the company secretary of Bajaj Auto Limited, Pune, from 2001 until 30th September 2023. He is currently with Bajaj Auto Consumer Finance Limited. He is on the board of few Bajaj Group companies, trust. He was the CFO and CS of Maharashtra Scooters Limited, a Bajaj Group company under the, of Bajaj Group company. Welcome, sir.
Thank you very much.
Thanks for your time. Apart from, he has been chairman of expert group of ICSI CSR Excellence Award for several years. He was founder chairman of Secretary Standard Board of ICSI in 2000, and also as a part of several expert study groups of ICSI on important professional subjects. He has served as a member of Accounting Standards Board of ICAI and high-level committees of SEBI, Ministry of Department of Company Affairs, CII, Maharashtra Chamber of Commerce and Industry and Agriculture, Pune Management Association and other bodies. He has represented CII in SEBI's working group on related party transactions in 2019-20, as well as in the Standing Parliamentary Committee on Company Law Matters. Thanks a lot. Such a varied experience, sir.
Thank you very much. Thank you.
Now, we also have our own Mr. Bala, as usual, who has 4 decades of experience in secretarial compliance. He has worked with FOESCO. India Limited. He is a regular speaker at ICSI CCGRT and contributes various magazines, including Charter Secretary. Yeah, welcome, Mr. Bala. So today we don't have Mr. Sudhakar with us, but he will join after say 20 minutes because he is giving some lecture in some program. So as usual, Mr. Sudhakar also is our he is consultant to Mehta and Mehta, and is also was associated with Reliance earlier. Welcome all. Thanks for your time. The topic about today's topic as regards from recently only, I got 2-3 cases where the clients were asking, they were added as a promoter when the IPO came, and they are not associated, how they can be removed. And I think many cases are coming where earlier IPO, when there was a boom, people has joined as a promoter and the company is not working well and they want to say that now we are not promoter. But when you introduce or allow yourself to be known as promoter and get listed, then you are responsible till you follow the process to remove. And what are the responsibility? So it's a very crucial position, which I think the promoter should be made known, gives to be introduced, and there should be promoter who knows that what is the responsibility attached to that. Today's topic is also very interesting. As usual, entire LODR is interesting. And we will have the benefit of Mr. Sridhar's, Dr. Sridhar's knowledge and experience. Today's our presentation is Kinjal Mistry, Associate Partner of Mehta Mehta, who had prepared a crisp presentation on the topic. Then, with all, I will request Mr. Sridhar to say a few words on the topic, and then Mr. Bala, and then we can start Kinjal presentation. Over to Mr. Sridhar. Thank you.
Thank you, Dipti, for the kind words of introduction. And I'm also privileged to be part of this webinar. And I'm aware that this is a very successful series of webinars which has been organized by Mehta and Mehta. And I'm sure many professional members are getting good benefit out of such webinars, such brainstorming sessions which are happening. And we, of course, we have my friend Bala also there all the time as moderator, and Mr. Sudhakar also my very good friend and a professional colleague. So I think this has been a very interesting session actually. And of course, about today's topic, as Dipti also mentioned, these are becoming quite critical these days with all this, changes happening, and a lot of them want to convert themselves into public from the category of promoters and vice versa. And then there's a lot of procedures have been laid down in the listing regulations. And I think they have been laid down after a lot of thought from SEBI, and all those conditions have been met, have been provided for quite well. And earlier, there used to be a little bit of an informal kind of method for reclassification, etc. But now it's all very systematically laid down, and the procedures have to be followed. But still, there are many areas where this process is not followed very strictly, and a few things are getting missed out by some of the companies, and it's not exactly as per the regulations. Some of the companies are not following the procedure very strictly. And then similarly, I think on this special rights being given to shareholders, I think a lot of new provisions have come in there, and which is also going to be very interesting and challenging. And a lot of things are going to happen there as well. And of course, the shareholding pattern is again another subject where a lot of issues come up from the stock exchanges all the time, and the company secretaries have to come out with their clarifications on some deviations, some changes, etc. So that is also another very important regulation. So which is 31, 31A or 31B or the 32 is all are important. And 32 also, of course, as we have seen, a lot of the deviations and the variations, how they have to be reported to the stock exchange, how they have to be reported to the audit committee, or how it is to be placed in the director's report and so on. So a lot of things have been provided for in the regulations, and all of us will have to go through all those things very carefully. And now I think Kinjal, of course, will be making the presentation, and I will add any points as and when the presentation goes on. I think these are some of my initial remarks on this subject. Will that be fine?
Yeah,
Thank you.
Yes.
Thank
Sure.
you so much.
Okay. Thank you, Atul. Thank you, Dipti.
Good morning to all of you. Yet again,
It is very nice to meet all of you in another program. As usual, Saturday morning is really, I'm looking forward on the last 2 years on these seminars, which have been really a knowledge enriching seminar. Now itself, we can see almost about 110 people have been there on the road. That itself shows what is the importance of the topic. I expect more to join. Especially in the LODR regulation, this 31 and 32 is more of a, what you call, compliance related issue and the procedure related issue, which is actually there. I would say rather these two regulations are very crux of the matter, affecting the promoters and their shareholding and their reclassification, etc. As Sridhar has brought in actually. And one of the things when we touched upon the reclassification, etc., there are a lot of procedural things have been laid down. One of the live issue, what we have been witnessing it on the either TV and the newspaper today, is relating to the Raymond's group of companies where Mr. Singhania and his wife are getting the divorce and the shareholding things is getting affected to the minority shareholders. The independent directors are breaking their heads. This is the live issue which is actually there, which many of you would be aware actually. Really speaking, although the regulations have been laid down, when it comes to the practicability, there are a lot of issues. What is the time at which the reporting really triggers? That is the point. Because one of the points, the special right has been given on the account of the divorce. The moment you say, I'm living apart, I'm separated, and other thing and all, whether it is divorce happened. Whether we are living apart from the two partners, the divorce has happened. What is the point of the divorce? Because when we talk about the divorce, as you are all aware, divorce is not that easy thing to go through in our country, because we believe a joint family system, people wanted to be united, this is a sacred, all those things are there. When we go to the court also, courts also have the various procedural issues before they are according the divorce. Because there is a family court, there is a conciliation process, there is a settlement process, all those things are all there actually. I have seen cases divorce, which is even going for 10 years and 12 years and 15 years. And whereas some of the cases, yes, it is there. It happens quickly also, but those are all really rare. So when we come to that, although the regulations say divorce is one of the things which has been actually provided, how far it is practical, what point of the time it triggers, etc. That is one thing which probably will be coming when we discuss in the appropriate time. Similarly, as Sridhar puts it, there are various conditions which have been laid down there. I think there are about 7 conditions which has been actually laid down if you want to the reclassify, which is actually the prerequisite. Because not like any other law, subject to I am doing this, I am seeking a reclassification, that cannot happen. One of the things, if the person is actually occupying a position of the KMP in a company, people might argue, because leaving a KMP will take the notice period time and other things and all those things. How can person leaves immediately? The time should be there and other thing and all. But what is the precondition? He should not be a KMP. That's all simple. So you cannot say that I am seeking a reclassification. I am going to step down from the KMP another 15 days, 1 month, 2 months, something. Those things cannot happen actually. So really speaking, there are a lot of nitty-gritties regarding the trigger point. What is the preconditions? And again, there is an automatic classification, as Dipti touched upon the issue that one of the promoters, one of the persons included his name as the promoter in the IPO issue. Automatically, he will be known as the promoter only once he subscribes to the IPO issue as a person. So these are all certain nitty-gritties which are actually there when we go along that. And not only that, there are a lot of reporting which is also there, because reporting refers the minutes, reporting refers within the time limit, etc. and all those things. But it is wrong to reconnect the regulation which is elsewhere prescribed and compare to this regulation, because each itself has had a separate objective for which. When we talk about the minutes, detail has to be provided. They are not asking the entire minutes. They are asking a particular decision which has been taken on this particular meeting. Again, they are providing 24 hours. Normally, you are all aware, whenever we take a decision, etc., what we do is normally we circulate the draft minutes on the agenda itself to the people. This is the proposed draft minutes which is expected to be put up on the board. So things are available. The moment the meeting is over, that particular point has to be picked up, that is to be reported. These are all certain reporting data guarantees. We have a benefit of our good friend, Mr. Sridhar, whom I know over 3 decades, Sridhar?
Yeah.
More
Easily,
than that,
yes.
I think.
More than that, yes.
Yeah. In fact, to recall with you, I have undergone my company secretary internship of a secretarial department in Bajaj Auto itself.
Yeah.
I had a privilege at that particular time, actually.
Yeah.
Long back when I started my
Yeah,
career.
3 to 4 decades of association, actually.
Yeah,
yes.
that is true. So I think he has got a variety of the experience in the different field. He is not only a company secretary, he is also a chartered accountant. And we have a benefit of his expert knowledge because we dealt in and out on all these matters, because the group in which he is working is one of the renowned group which is well recognized. So let us have the benefit of him. So with these words, I'll stop here. I'll ask Kinjal to proceed with the presentation. Over to Kinjal, please.
Yeah, Kinjal.
Just a brief comments. This regulation is a very important as a company secretary. If you're a whole-time company secretary of any company, I remember in 2015 there was a case, of a Gujarat Heavy Chemicals, where SEBI, as for the regulation, all the companies, they were supposed to provide a shareholding pattern on a quarterly basis. That's what Regulation 31 says. And somewhere this company called, since it is a public and I'm taking a name, this company, Gujarat Heavy Chemicals, the company secretary has submitted the shareholding pattern to the stock exchange. Somewhere the stock exchange discovered that look, the shareholding pattern which is submitted by the company secretary is not correct. And after the exchange of mails, which went for almost a year, where SEBI discovered that look, the shareholding which has been submitted by the company secretary is not correct. And the first time the SEBI has penalized promoters, they've penalized company also, and probably the first time they also penalized the employee company secretaries. So I think this regulation is very important, and either you're in a practice or in the job, one should be thorough with this regulations. Yeah, Kinjal, you can, this is what my initial remarks. And we also recognize presence of Ashwini, our senior partner, our Alifia Sapatwala, who's also part of our team. Thank you, Ashwini, being part of this. Yeah, we can start, Kinjal.
Yes, sir. Start.
Our regular senior participant, Mr. Mallikarjun, is also there. So we recognize his presence also.
Good morning, everyone. My seniors have already given a bird's eye view of the regulations. So let's delve into the nitty-gritties of these regulations. Regulation 31, shareholding pattern. This is a compliance set of requirements in Regulation 31. It pertains to the shareholding pattern and holding of securities filing requirement. So in this, there is a routine compliance requirement on quarterly basis, and there are event-based compliances which listed entity needs to comply with. So upon the listing of the securities on the stock exchange, shareholding pattern is required to be filed 1 day prior with the exchanges. On quarterly basis, within 21 days from the end of each quarter, the shareholding pattern requires to be filed. Any capital restructuring of the listed entity resulting in more than 2% change of total paid up share capital, that needs to be filed within 10 days. For entities which are listed on SME exchanges, these compliances will be on half-yearly basis. So that is also required to be done within 21 days from the end of each half year. A couple of circulars I have mentioned out here. These are pertaining to the requirements of shareholding pattern, like December 2018 circular for the format which has come up for the shareholding pattern filing. For BSE and NSE listed entities, they have made it mandatory to file the shareholding pattern in XBRL mode. August 13, 2021 format for the promoter and promoter group entities. and December 2018 again circular, aligning it with the company's significant beneficial owners rule. So disclosure of significant beneficial ownership is also required to be done in the shareholding pattern of the listed entity. Regulation 31(2), 100% of the shareholding of promoter and promoter group requires to be maintained in dematerialized form on continuous basis. And under Regulation 31(3), compliance with the circulars and the directions issued by the SEBI, that is the board, with respect to the maintenance of shareholding in the dematerialized form has to be complied on ongoing basis. Regulation 31(4) needs a special mention out here. Earlier, the companies, listed entities were not specifying promoter holding in case of nil shareholding. Hence, to plug this, the circular has come in of 2018, and now the entire, I mean, even if the promoter is holding nil shareholding, it needs to be disclosed in the shareholding pattern.
I think maybe one more point that we can probably note is that the shareholding of promoter as well as promoter group will have to be disclosed separately.
Yes.
It's not only the entities in the group of promoters and the subgroup of promoter group. I think we'll have to distinguish between promoter and promoter group separately. Yeah, please.
Yes, sir.
Yeah.
Now we'll move on to Regulation 31(a), reclassification as promoter or public. The background to this regulation is earlier there was clause 35 under the listing agreement, wherein we were filing the shareholding pattern detailing the promoter and promoter group shareholding, and wherever the promoter was already mentioned in the RHP or DRHP, the promoter continued to be reflected in the shareholding pattern as a promoter. There was no mechanism for converting it into moving it into the public category. Hence, this regulation is addressing it under the LODR regulations of 2015. Prior to starting with the regulation provision, I would like to reiterate the definitions which are important while discussing these provisions. These definitions flow from ICDR. Promoter shall include a person who has been named in the draft offer document or identified as an issuer in the annual return file, who has control over the affairs of the issuer directly or indirectly. Over here, word control is defined and flowing from SAST regulations, in accordance with whose advice, directions, instruction the board is accustomed to act. However, financial institutions or foreign venture capital, alternative investment funds who are just holding merely, say 20% or more of the equity capital will not satisfy this requirement. Regulation 2(1).
Just a minute. Nowadays, you have so many private equities. They hold the shares in the company, and they, at the time of the IPO or offer for a sale, they offload their share in the in the market. So for all purpose, so anything about 20%, they will be treated as a promoters, or what is that? So that's what Kinjal it says, right? If they are holding more than 20%, then they also should be classified as a promoter.
No, shall not be deemed merely by the virtue of shareholding, sir. So just because they are holding this much, they will not be categorized as a promoter.
Okay, but all this, the private equity, they also have a nominee sitting in the board. So for all purpose, they also have some kind of directly or indirectly control on the decision making of the company. So yeah, this is what my observation, Kinjal.
Yes, so they have to satisfy the other requirements also prescribed under these regulations, like the director is there or they are having direct control over the affairs. So that needs to be fulfilled. Unless and until that is there, just mere shareholding is there, then they will not get categorized under the promoter category. That's what the regulation defines it.
Regulation. Mr. Bala, you wanted to take a question. There are some important questions, on the chat box. Mr. Bala?
Yeah, we can take. Yeah. 1 minute. Can a public charitable trust be part of the promoter group entities, as they cannot hold shares in their name and also do not fall under the definition of entity?
Very interesting. Huh?
Yeah, normally public charitable trust holdings will not be part of the promoters. Because that is, once it is a public charitable trust, so it is supposed to be in the interest of the public charity. So that cannot form part of the promoters.
So immediate question came, what about private trust?
Yeah, private trust, of course, can get covered.
Yeah.
Yeah.
A listed company has a promoter who is not traceable for the last 4-5 years, located abroad. Probably he is no more, and that no legal hats. He is holding the physical shares of the company. As per the SEBI LODR provisions, the entire shareholding of the promoter should be in the demat form. The company wants to reclassify him as a public shareholders. How can we do that? Can you advise?
I think it's require a lot of study actually, the facts of the case. Yeah, Mr. Sridhar.
Yeah. I think,
There are
of course,
many issues in this.
some of the more detailed provisions are just going to be part of the presentation now. I think as and when we go through that, I think things will become very clear.
Yeah.
Okay, great.
Yeah.
And there is a question further that private trust with nil shareholding also can be the.
Yeah.
Because
See,
can.
I think as I think Bala also mentioned, whether all promoters with nil holdings have to be shown as part of the shareholding pattern or not. So, see, once you have shown it, then you cannot exclude it. So, you will have to continue to show it. But at the same time, there are two different views about the new entities which are coming as part of the promoters or promoter group, where they are not having any shareholding, whether they should be included in the shareholding pattern or not, because there could be a situation where the list of all such could run into maybe 100, 200, 300 numbers also, and they may be having no shares at all. So if you are not shown it as a promoter group anytime, there is no need to again show it to them, even show it in that pattern, even if because there used to be a little bit of a doubt, ambiguity, because some of the stock exchanges like NSE used to say that you have to show those with nil holdings, but that you will have to show provided you had already shown them in the group as a promoter, and if you have shown them once, then you cannot exclude, but otherwise there is no need to include everything with nil holding as part of the shareholding pattern.
Okay.
So there are two schools of thought on this. When this amendment came, after that they started showing it with nil shareholding as well. So initially, if you were not showing this amendment, a lot of companies started showing with nil shareholding.
Yeah, they have been showing it, but actually not required, because strictly once you have shown it, then it is difficult to exclude. But suppose a new company has been formed in the group, so they may be holding no shares at all. You need not again just put it in the pattern and say that this is again another promoter group company which is with nil holding, etc. So it can go on, and then for some groups it can run into very huge numbers, 200, 300, 500 numbers. I mean, you can't give a long list of promoter group companies with nil holdings, which may be serving no purpose at all.
So it is advisable to continue the practice that the company has followed since before.
Correct. But if you have already shown it once, it is difficult to exclude.
Right.
Yeah.
Yeah, Kinjal.
So promoter group definition, it includes the promoter, the immediate relative of the promoter, which is the spouse, the parents, siblings, and the children. If the promoter is a body corporate, then the subsidiary of the holding company of such a body corporate, any body corporate in which the promoter holds 20% or more shall also be included. In case the promoter is an individual, then any body corporate in which the 20% or more of the equity is held by such promoter or an individual or a firm of HUF or a firm or an HUF will also be included here. Any body corporate which a body corporate as defined above holds 20% or more of the equity shares. And all the persons whose shareholding is aggregated under the heading shareholding of the promoter group. Again, over here, a proviso is given with respect to the financial institution, scheduled bank, alternative investment funds, mutual funds, IRDA, companies registered with IRDA out here, that merely, by holding 20% or more of the equity share capital, mere by that fact will not be categorized as the promoter.
On the other point regarding that immediate relative, of course, Kinjal has correctly mentioned about the parent, brother, sister, or child of the person, but it's not only of the person, is also of the spouse.
Yes.
So that means, so that point has to be noted. So it becomes a little wider. It's not just of that immediate relative of the person, is also of the spouse. Spouse of the person. Yeah.
Yeah.
Yeah, sure.
Regulation
Please go ahead.
21E of ICDR, fugitive economic offender, means an individual who has been declared as a fugitive economic offender under Section 12 of the Fugitive Economic Offenders Act. Willful defaulter or a fraudulent borrower means a person or an issuer who or which is categorized as a willful defaulter or a fraudulent borrower by any bank, financial institution, or consortium thereof in accordance with the guidelines issued by the RBI. Regulation 21E of SAST regulations, control definition. This is what, the promoter definition refers back to. So control includes the right to appoint majority of the directors or to control the management or the policy decisions exercisable by a person or persons acting individually or in concert, directly, indirectly, including by virtue of their shareholding, management rights or shareholders agreements or voting rights or in any other manner, provided that the director or officer of a target company shall not be considered to be in control over such target company merely by virtue of holding such a position. Now we'll come to Regulation 31A(1) of LODR. For the purpose of this regulation, promoters seeking reclassification means such promoters or persons belonging to the promoter group seeking reclassification of status as public. So this refers back to the ICDR definition.
There is one question has come. If a relative of a promoter who do not have any shareholding in the company, but she is having 20% in another company, will it need to be disclosed as promoter group?
No, that will not be required.
It will not be, because when we talk about the promoter group, we are talking with reference to this particular company.
Yeah.
If he is not holding any shareholding in this particular company, he is out of it. If he is holding some other company, then that has to be examined with reference to the some other company, not in this company. Yeah. Go ahead.
Then subclause B talks about persons related to the promoter seeking reclassification. This again refers back to the ICDR regulation where it says subclauses 2, 3 and 4 of the promoter group entities. That means 2 is immediate relatives. 3 is promoter as a body corporate, and 4 is about individual promoter. These clauses are reflected here again. We'll start with Regulation 31A. The regulation is divided into procedural part, which requires to be done or taken care by the listed entity and the promoter group seeking reclassification. Then certain other scenarios wherein the regulation talks about how the promoter group will be automatically reclassified as public or reverse scenario, and certain exemptions which are there. So procedural part includes, so promoter will give a request. Promoter includes the persons, related to the promoter seeking reclassification. They have to make a request to the listed entity for making such a reclassification, justify it, give a rationale for such a reclassification, and also give us a description of the satisfaction of the conditions mentioned in 31A(3)(b). This is a very important clause of this regulation. We will deal with it in the next slide. Board meeting. Subsequent to the receipt, the board meeting has to be held immediate next board meeting, this request may be considered, or within 3 months from the receipt of such a request. Earlier, the provision, was talking about a lengthier period, that was 6 months period, which has been shortened to, work this out in a better manner. Then the company will have to hold a general meeting, and such a request shall be placed before the shareholders in the general meeting, along with the views of the board for such a request to be considered. In this, the promoters seeking reclassifications and the persons related to them shall not vote or approve such a reclassification request. This has to be passed or approved through ordinary resolution, so postal ballot can also be done. Need not have a physical general meeting. There is a proviso out here which speaks about if the promoters seeking reclassifications and the persons related to the promoters together do not hold more than 1% of the total voting rights in the listed entity, then this requirement need not be complied with. That means general shareholders approval need not be taken. And if the reclassification is pursuant to a divorce. Sir, Bala sir, you would like to say something?
Yeah, this is
Yeah.
what I said in the beginning also. When
Yeah.
you say pursuant to the divorce happens when actually? What is the trigger point?
Correct.
That is the pertinent question here. Although the regulation has given the exemption, because as we have seen in the courts, the divorce is a very lengthy procedure. It is not actually for 6 months or 1 year and all. Even we have seen lengthy period of 10 years, 12 years, 15 years also, the divorce keeps going on actually. Because the divorce is nothing just because I have made my intention to get divorced, or I have started living divorce, or we are not living together. That does not mean the divorce. Divorce is ultimately the final stamp which is put by the court. The people are divorced. That is the point. So it is actually remains as the exemption, but how far it is practically is going to be there is the question. Your views, Sridhar?
Yeah, absolutely right. Because they are not defined divorce here anywhere. But I think we should take a stand, as Bala mentioned correctly, that divorce would be a legal divorce, which means with a proper order of the court or the family court, etc. So if that is not there, then that exemption will not be available. So like that Raymond's case, there may be an intention for them to divorce, but that intention does not actually, it cannot be construed as a divorce which is already completed. So in this particular case, for example, if theoretically, hypothetically, if somebody goes for a reclassification as public, then they will have to go through the shareholders' approval. And again, there is another point to be seen is those persons who are seeking reclassifications, they also cannot vote in that particular resolution. So the exemption is not available to them. So I think I agree with it that although it's not clearly defined in this regulation, I think we'll have to consider it divorce means it's a legal divorce.
So theoretically, it is available, but practically implementation.
Practically, yes,
Yeah.
cannot be used. Yes.
There's one question has come actually. Promoter is holding less than 1% and he is complying with all other conditions of 31A as well, applies for the reclassification. Does the board has the right to reject, or they have to just forward it to the stock exchange?
No, that has to be forwarded to the stock exchange directly, sir. Provided the 31A 3B conditions are all met.
Yeah, all the conditions. Yeah.
Ultimately, the board has to approve it, and then it has to go for the recommendation. So, which means if the board has not approved it, then it cannot go to the stock exchange.
If a promoter including, 1 minute, if the promoter including having the 8% stake before IPO and reduce their stake to 1% during 1 to 3 years, then still the 1% entities exemption will be applicable to reclassification of the promoter.
He is less than by 8%, is it?
No, he was actually having 8% at the time of the IPO.
Okay,
And he is reduced the stake gradually to 1%.
okay.
So the question is whether the 1% criteria will be applicable as an exemption. Will he be able to get the reclassification?
Exemption is only with regard to the shareholders approval, but otherwise the stock exchange approval, the board approval and other approvals would all be required.
Okay.
Yeah.
Then there is somebody is asking approval means what? Approval means it's a simple term. Reclassification is actually subject to the condition it is approved or not approved. That's all. Either it is rejected or approved. I don't know what is the exact question.
think-
approval means
I
what.
think the subsequent slides of Kinjal, I think will explain all those things. I think
Okay,
maybe
okay.
we can give
Yeah.
some time to Kinjal.
What I can do, what I think, Kinjal, you can say that this topic is over now. We can take the question because, like you have mentioned, application process is still last line. You have to say, and the question is started. So let's
Yeah.
be covered.
Yeah. Yeah,
Then
we'll
all
take
the
the
questions
question.
we can.
Yeah.
That will be the right way.
Yeah.
We'll cover
Yes.
all the question participants, but let's finish the current.
Yeah.
Okay.
Ma'am, we should finish the regulation entirely and then we should take up the question because a lot of other.
Right.
Yeah.
Yeah.
Correct, correct.
So then Kinjal, because you know the slides is getting over for this regulation, you declare that now you take the questions for it.
Yeah,
Okay?
sure. In the notice of the general meeting, the explanatory statement will give the pre and post shareholding, pre and post to the reclassification requirement. These details need to bring out even the reasoning and the satisfaction of the 31A3B conditions which the promoters have to fulfill. All of these will reflect in the explanatory statement to the notice of the general meeting.
As a general point, I can just mention, of course, I went through about 7 or 8 resolutions as well as the explanatory statement provided by various companies. And majority of the companies have not really given the rationale for the reclassification. And they have just, of course, said that all these conditions are met and they have described all those conditions and saying that they have met. But strictly speaking, the rationale also should have been mentioned. But I think even the stock exchange are not really gone into that much minute detail. But I think to make it perfect, I think rationale also should be properly mentioned.
Yeah.
Kinjal, yeah. Correct.
Subsequent to the members' approval, stock exchange application has to be made for reclassifying the promoters into public category. This has to be done within 30 days from the approval received by the shareholders in the general meeting. In case the entity is listed on more than one stock exchange, all the concerned stock exchanges shall take a joint decision on the application. The application to the stock exchange basically includes all the documentation, the pre-post shareholding requirement, confirmation from the promoters that all of these conditions have been met under Regulation 31A3B, and the rationale and the notices, the explanatory statement, and the resolution passed by the board and the members, certified true copies. Under Regulation 31A3C, listed entity has to ensure that it is compliant with the requirement for the minimum public shareholding. Its shares have not been suspended from trading on any of the stock exchanges, and there are no outstanding dues to the board or the exchanges or the depositories. This is again a pre-requirement on the listed entity side. Then there are certain stock exchange disclosures which are required to be done within 24 hours from the occurrence of the event. Number one, it is receipt of the request for reclassification. Moment it is received by the listed entity from the promoters or the person seeking reclassifications. Within 24 hours, such a receipt of the request has to be disclosed to the stock exchange. Minutes of the board meeting where this request was considered, including the views of the board on the request. So basically, extract of the minutes has to be shared with the exchanges. Submission of application. Moment the submission of application is done for reclassification of the status as promoter of public by the listed entity, disclosure will go to the exchange. And once the decision of the stock exchange is received, again, the communication has to go within 24 hours to the exchanges.
Here actually the minutes of the board meeting considering the request, which means the 24 hours to start from where is one of the questions actually. In fact, the 24 hours starts from the date of the board meeting, or 24 hours starts when you actually make the minutes of the board meeting, or the 15 days time draft minutes, whether that is there, or in the 22 days time, that is after the draft minutes are circulated, it is approved within 7 days by the directors or any objection, etc. and other thing and done. What is the trigger point here is actually one of the questions.
Yeah, but I think there's a drafting lacuna here.
Yeah.
So they should have mentioned the date of the board meeting, considering such requests. I think that by using the words minutes, they have unnecessarily put some confusion in this. But actually speaking, it should have been the date of the board meeting, considering such request, which would include the views of the board on the request. And at the most, as I think Bala also mentioned in the opening remark, so all this should be properly put in the agenda itself, and then then the final resolution part and the minuting part, which includes the views of the board on the request, should all be properly taken and should be disclosed within 24 hours. So I think we should take it as the date of the board meeting only for this purpose. All those 7 days, 15 days, 21 days, 30 days, I think we will not be able to take advantage of that.
Correct. You are absolutely right. It is actually from the date of the board meeting within 24 hours. As you rightly said, this particular item minutes has to be prepared on that particular day. That is it. Nothing else. That extra is to be provided to them.
Absolutely. And we can also note out of these 4, there is that event of the shareholders resolution is not appearing in this. But that is because in any case, the shareholders resolution would be disclosed to the stock exchange. So there is no need to specifically mention in 31A8. So that's why I think that part has not been specifically mentioned. But strictly speaking, that is also one of the important events in this particular part of approvals.
Agreed, sir. Under Regulation 30, we have to make the required disclosures within half an hour. But along with this, these are specific requirements to comply with this regulation.
Correct.
I'll move on to the other slide. Now, Regulation 31A3B. This stipulates the conditions which are required to be met by the promoters or the persons related to promoters seeking reclassifications. These are not disjunctive conditions. These all have to be met by the promoters to satisfy the criteria and to get themselves reclassified under the public category. We'll pick up each one of them. Promoters seeking reclassification, persons related to the promoter seeking reclassification shall not together hold more than 10% of the total voting rights in the listed entity, exercise control over the affairs of the listed entity directly or indirectly. It's pertinent to mention out here that though promoter group and promoter and promoter group definitions have been referred from the ICDR, which refers to the control over there, and it goes back to the CEST. However, despite that, LODR has specifically mentioned exercise control over the affairs of the listed entity directly or indirectly out here. Third, have any special rights with respect to the listed entity through formal or informal arrangements, including through any shareholder agreements. Fourth, be represented on the board of directors, including not having a nominee director of the listed entity. So none of the promoters should be holding any of the board positions. To act as a KMP in the listed entity, none of the promoter or the persons related seeking reclassification should act as a KMP in the listed entity. And 6th and 7th, willful defaulter under the RBI guidelines or fugitive economic offender. So all of these conditions have to be met strictly. Promoter cannot, take a stand that only one of the conditions is not met or kind of. I'll move on to the other slide.
Yeah.
I'll come to Regulation 31A4, which talks about automatic reclassification. So this is talking about the moment any of these compliances which are required in the initial stage, if subsequent to the reclassification under the public category, if the promoter does not fulfill any of these criteria, they automatically get reclassified under the promoter category. So out of that, the 5 conditions have been considered here. 3 are without any time limit, which is holding more than 10% of the voting rights, shall not exercise control over the affairs, or shall not have any special rights with respect to the listed entity through any of the formal or informal arrangements or shareholder agreements. And the other 2 conditions, that is representation on the board of directors and to act as a KMP. So there is a cooling of period given over there that he or she who is seeking reclassification. I think somebody is unmute. Shall not be represented on the board of directors, including not having a nominee director or nor act as a KMP personnel in the listed entity of not less than 3 years. So subsequent to 3 years, that person can be appointed on the board or as KMP, but next 3 years, it should not. I mean, the person should not act as a KMP or a member of the board of directors. However, the previous 3 conditions with respect to voting rights, exercising control, or any of the specialized, these are continuing compliance requirement for the promoter group. Failing which, if any of these conditions are not fulfilled, there is automatic reclassification of the promoters and the persons belonging to promoter under the public category. Now, to reclassify again as a promoter from the public category, the concerned group or the promoter or the persons, they will have to make an open offer under the regulations, under the SAS regulations 2011. These are some of the other provisions of the regulation clauses, which talks about different scenarios. 31A6 talks about transmission, succession, inheritance, and gifting of shares. In case of such an event, immediately the new person who is coming in or the promoter entity will be classified as a promoter or persons related or under the promoter group. If subsequent to such a reclassification as a promoter, say on succession or gifting of shares, if the person does not want to continue under the promoter category, the person will have to comply with 31A3B conditions and apply for the reclassification request under public category. So the entire process flow has to be followed. And in case of death of a promoter or a person belonging to the promoter group, such a person's name will immediately be removed from the promoter category or persons belonging to the promoter group. Under regulation 31A7, if the
maybe I can just add one point that there is one situation which is not envisaged in this, where say in the case of a transmission under process, for example, on the case of a death, the person automatically ceases to be included as a promoter person belonging to the promoter group. And then when the process of transmission or succession is completed, then the recipient is classified as a promoter. In the intervening period, so during the process of transmission or succession, then there what happens is the question. There the executor or where it is lying in the estate of that particular person, that will also be part of the promoter group. So that is not specifically mentioned, but then we'll have to take it as part of the promoter group only. That is the intervening period. And again, on that second point, I mean, the gift of shares, for example, that is where I think we have seen a few cases where some promoters have applied for reclassification, where because of gift of shares from the promoter group, they have been classified as promoters, but since they have absolutely no control over the affairs, I mean, they are not exercising any control over the affairs of the company. So they have in fact sought for reclassification. But as Kinjal mentioned, it will be subject to compliance with all the conditions specified earlier. Yeah, go ahead.
So to add on to what you've just mentioned with respect to gifting, so there is one informal guidance issued in the case of Mirza Enterprises, wherein the promoter's daughters were given the shares, from the promoter category actually, and 2 of the daughters post marriage, and they had said the informal guidance with respect to that. Do we need to follow the process flow of general meeting approval? And
voice is gone.
Am I audible now?
Yeah, you're audible.
Yeah.
Not audible, actually. Yeah.
You're audible.
Yeah, so in that informal guidance, then the SEBI had said, no, the process has to be followed because gifting of shares will lead to, although it may be less than, the required percentage, but the process flow will have to be followed. Although the daughters were no way correlated with the controls or the regular operations of the company.
Yeah.
So regulation 31A7, if the listed entity is left with no promoters under the promoter or promoter group category, then it will be known as listed entity with no promoters. Now regulation 31A9. So these provisions, have been introduced with respect to and 31A10 that pertains to the scheme of arrangement. The first one under clause 9, it talks about if the entity has gone in for a resolution plan under section 31 of the insolvency code and the reclassification is pursuant to that or pursuant to an order of a regulator under any law, subject to the condition. The insolvency code clause was already there. However, for the order from any other regulator, over here, this clause was introduced with respect to Yes Bank's case, wherein the RBI had given the reclassification of the promoter thing. However, it could not be met under any of this. That's why this clause has been introduced. Or the SEBI directions under in CP Power's case, wherein SEBI had issued the direction, but the company did not go for reclassification of the promoter. So to tackle these kind of cases, this clause has been introduced over here. An automatic reclassification will be done. And the provisions of subregulation 3, which is the procedural requirement of general meeting and the other process flow, or the stock exchange requirement under 8AB, some of the cases which is pertaining to the board approval and all, need not be complied with. Under regulation 31A10, reclassification pursuant to an open offer or a scheme of arrangement. In such a scenario, if the promoter has explicitly disclosed it in the letter of arrangement or a letter of offer or a scheme of arrangement, then the provisions are, some of the carve-outs have been given over here with respect to the procedural requirement. There is automatic reclassification taking place of promoter into public category. Yes, I'm done with regulation 31A and we can take the questions if there are any.
Sure. There are a lot of questions are there actually. Do we need to take a letter from the promoter for reclassification shares in diverse case? I think any reclassification the promoter is seeking, he has to make a request formally to the board, na? Correct?
Yeah.
And in this particular case, when you are talking about the diverse, so he has to also give a certified copy of the diverse order issued by the court. Because that is what we said also, that is the point where the diverse actually triggers upon.
That application to the company and then the board approval, etc., that in any case would be there.
Yeah.
So even in that case, it will be there. Only whether exemption is available for the shareholders' approval or not, that is the only thing where there can be a little argument. But otherwise, the application to the company and then board approval and the application to the stock exchange, all those requirements will anyway will be there for even divorce cases.
Yes. So it is not a suo motu requirement that the listed entity will start the action on this front. There has to be intimation from the promoter's side.
Exactly.
Correct. Exactly. What you are saying is absolutely correct. I think the promoter is complying with all the conditions of 31A. Board has no power to reject.
No, the board, of course, ultimately has to, if it rejects, of course, it will have to give a proper reason as to why it is rejecting. But it can have its own consideration as to why it, suppose you say that you are having no control, the board may disagree with that. I mean, it's not necessary that everything that is stated by the applicant has to be accepted by the board. And if the facts and circumstances are such that those conditions the board feels are not met, the board can reject it.
You are absolutely right, Sridhar. I agree with you. Although you say that everything is actually complying with the board as does have the right. When you come to the control, because control, as Kinjal has said, it has been defined in the very different ways. He need not be a board member, but we also seen in the past what you call that shadow directors.
Exactly.
The board accustomed to act as per the instructions of the person. If that sort of the control exists, the board knows, board has come to know, they have the reason to believe that he is still having a control, in which case they not necessarily request to go by the application what he has given and I have fulfilled 1, 2, 3, 4 tick mark. It is not the tick marking exercise. That is where the role of the independent director, other directors and all these things involve quite a lot. So as you rightly say, yes, board can accept it subject to fulfilling all the conditions if they are satisfied. If they are not satisfied, they have all the reason to reject.
Absolutely. Absolutely.
And the exemption is just for the shareholders' approval, right?
Exactly.
Yeah, that is right.
Yes, exemption is only for the shareholders' approval.
Yeah.
That-
If the promoter group seeking the reclassification having 6% of share capital, can the requirement of the general meeting approval be exempted?
No.
24 hours from the conclusion of the board meeting and not from the date of the meeting. 24 hours.
Of course, from the conclusion of the meeting, no doubt.
Yeah, that is what it is. It is understood.
Yeah.
Yeah,
From
that
the
is right. Yeah. Once these conditions are met, board cannot reject, I think. Oh, that we have discussed, we have answered actually. Your PPT is not visible. You have to check at your end because it is quite visible at our end.
Correct.
A company under the promoter group is sold by the group to outside party. What is the procedure to reclassify them?
I didn't get the question, sir. If you can repeat.
A company under the promoter group is sold by the group to outside party. What is the procedure to reclassify them?
Procedure is the same. I mean, they have to comply with all those requirements, all those 7, 8, there's conditions. They have to make an application, say that all those 7 conditions are met and all those things. So one by one, they will have to comply with all those, and then they can do it.
Is it mandatory to file the application in both the stock exchanges and payment of fees of 50K to both the stock exchanges?
Yes, sir. It has to be done. In fact, not both the stock exchanges, any of the other exchange also. It's a joint decision which the exchanges will be taking together. So application has to be made everywhere.
Absolutely correct. Absolutely correct.
In case reclassification of the promoters, all earlier promoted individually holds less than 10% of all the promoters altogether.
No, the promoters and the promoters related to the promoters who are seeking reclassification should be holding less than 10%. So if they are holding more than 10%, then they are not eligible.
Actually, it is with reference to the promoter who is actually seeking the reclassification, he's holding.
Exactly. Yeah. Exactly.
A listed company has a promoter who is not traceable from 4 to 5 years, located abroad, probably is not having any legal heads, etc. He is holding the physical shares of the company. As per the SEBI LODR regulation, the entire shareholding of the promoter could be in the demat form. The company were to reclassify him as a public shareholder. How can we do that? Please advise. This is not the earlier question we started with.
I mean, all the promoters have to be holding everything in the demat form. So that is already mentioned.
Yeah, because in this particular case, he says there's one of the promoter who is not traceable for 5 years. Probably has gone abroad, whether it is no more or no legal hair, nothing. And shares are in the demat form. So whether company can classify you public shareholder.
No, without without following the procedure, you cannot suddenly change it to public. It has to go through those 7 conditions.
Yeah, that is true. Please elaborate on regulation 31A 10 reclassification post open offer.
I can see one question. Can a promoter file an appeal with SAT against board rejection of his 31A application? So I don't think you have to go to SAT for that. Even SEBI itself is good enough.
Most of the time in such a situation, board never accept such a reclassification. Can the existing promoter directly disclose to SEBI?
Yeah. No, they can disclose, or as they can say that the board has wrongly rejected it and it can apply to SEBI, and then through SEBI, it will be a complaint which will be against the company to SEBI, and the SEBI will seek explanation from the company.
Yeah, you're right. He has to actually first approach to the listed entity only. He has to go through the procedure.
Correct.
And as you rightly say, if there is something either, he can always take up the matter with the regulator again against this decision. That can be done.
Correct.
In case of the marriage or the addition of the spouse to promoter category, whether reclassification approval is required from the stock exchange.
Not required, actually.
Can a promoter file an appeal with the SAT? That you said actually, it is not. Outgoing promoter shall be reclassified from a date the company receives intimation of open offer, or the company has to call general meeting.
Outgoing promoters should be reclassified from the date of No, if it is basically based on offer, restructuring, etc., then it is you don't have to have go through all those procedures.
Yeah, I also presume like that only because when the outgoing promoter is there, means this is not is seeking a classification, etc. This is no longer, so you don't have to go for the general meeting.
Yeah, if it is pursuant to an open offer or scheme of arrangement, etc., then these provisions don't apply.
Outgoing promoter or a new promoter can vote in a general meeting.
Of course, they can definitely vote.
I think that is all the question for the time being.
I think Mr. Pramod Bhai has raised the hand. IT department, unmute Mr. Pramod Bhai. Pramod Bhai, you wanted to say something, then you. Pramod Bhai, I think there is an issue.
There is somebody has put a question.
Please take.
It will be a general complaint to the SEBI or any specific department the promoter has to file the complaint with.
It will be a general complaint to SEBI against the company.
Is Pramod Shah, are you there? Would you like to speak? Mr. Pramod Shah? He is on mute actually.
Sir. Thank you.
Yes, please. Yes, Mr. Pramod Shah.
No, thank you very much. And I congratulate you for a very good moderating what you have been doing from event to event. And I congratulate Dipti and the SLY for the consistency in all these webinars, which are going very well continuously on every Saturday. So when Saturday comes, we know that MNMB is there always. So we are proud of that. And I'm sharing the information and knowledge what we are doing. And we take the details from the YouTube and circulate to all members also. Thank you.
Thank you, Pramod Bhai.
Thank you, Pramod Bhai.
Yeah.
If the promoter
one
holds,
more question.
if the promoter holds more than 20% stake and wants to apply for the reclassification as a public category, can they do or can apply to the exchange?
They cannot, because once they are holding more than 10%, they are not eligible at all.
Yeah, that's all I think. Kinjal, we can move to the next one. Oh, one more question has come. Shareholder, what is it?
No.
No. Yeah. Yes, Kinjal, you can move forward.
Sir, I would like to just end with a few notes on this regulation, actually, which are my thoughts. I find the 10% one, the question which was being asked right now, 20%. we find a little like minimum public shareholding requirement is of 25%, and even for open offer requirement is also under 25%. So whether LODR will be brought in line with that or not, that is something which we'll have to look for. Non-cooperating promoters, or where the promoters trace out is not available, that is something which we'll have to look at it. And move on to the other regulation now.
1 minute.
That
There are
Anamika Raju has raised the hand. Allow her. Anamika should be allowed. 1 minute, Kinjal. Anamika, you can speak. You can unmute and speak.
Anamika, you are unmute actually. Can you unmute and talk?
IT department, Anamika is unmuted. I think.
She's not there.
Yeah, okay.
Even Dharmesh
You
is
can go
raised
ahead.
the
Dharmesh Parekh has raised the hand.
Yeah,
Dharmesh
yeah,
Parekh.
sir. Yeah,
Yeah.
sir, I've raised the question, but just need one, not need clarification. In case of outgoing promoters, the shareholding of promoters shall be less than 10%. So if suppose there are 5 promoters or 6 promoters, then altogether they should hold 10% or individually 10%.
It's all together, sir.
That is each
Altogether
one who
means
is
suppose
making an
there are,
application. Each one who is making an application will have to hold less than 10%.
okay, but individually, right? Not all together.
Individually.
No, individually. This is
Individually.
actually the person who is seeking the reclassification individually. That is the
Okay,
regulation.
sir. Okay, thank you.
Yeah.
Thank you, sir.
There are 2 more questions have come. There are total 2 groups of the promoters. What if one of the promoter group wants to apply for reclassification? Also, the promoter group holds more than 20%. Can it be divided into subgroup in order to file application for the reclassification?
No, but so many other conditions have to be met, now whether they are having control over the affairs of the company or not. So it will depend on the facts and circumstances of the case. So just because they desire to be classified as public or not, I mean, whether they are in the board, whether they are running the company, whether they are having the control over the affairs of the company directly or indirectly. So all those things will have to come into the picture.
Now, you are absolutely right, because all the 7 conditions, as we said in the beginning also, it is actually the precondition which has to be tested. If they fulfill all the conditions, then only thing can go through, otherwise it is not.
Exactly.
Rajesh Arora is decided. If the divorce petition is filed, however, the court has yet to grant the divorce, can the promoter, while the petition is pending in the court for divorce, go ahead with the getting him or removal from the promoters group? No. Because divorce, whether it is happened or not, is ultimately the divorce order. It is not in the process. We don't know, it may end up this way or that way. So because the condition which is laid down is only the divorce, upon the divorce only. So that will be the ultimate thing. I don't think he can go ahead, my divorce petition is pending, I'm seeking a reclassification. I don't think so. What is
No,
your
you will
feedback?
have to meet all those conditions. That means all those 7 conditions will have to be met. And plus all those requirements, whether that application, then of course board approval, stock exchange approval, and shareholders approval, etc., will all be required. And if everything is done, even in the case of divorce, if these conditions, I mean these requirements are met, they can be reclassified, not a problem.
If the promoter dies, he automatically ceases to be a promoter. So how come his legal heir who applies for the transmission again becomes the promoter automatically?
So because ultimately it is presumed that it will go to a successor who will be part of the same family. So it will be considered as part of the promoter. So that's why that first condition itself is saying, in the case of a transmission or succession or gift, etc., they will be deemed to be part of the promoters.
Yeah, probably if it is
Promoter
yeah.
and promoter group.
Yeah. If it is otherwise, he need to seek the reclassification later.
Yeah. Exactly.
That is
And
the
in
only
case he
process.
doesn't want to be classified as promoter group, then he has to meet all those 7 conditions and then he has to
Yeah,
go.
he has to reclassify and make an application, and he has to fulfill all the conditions are met actually.
Correct. Correct.
What about the promoters disown their own children by making a public announcement?
Now again, the same conditions. I mean, even if they disown it, ultimately they will have to go through all those the processes they will have to follow, and conditions they have to meet. Once they do it, and if the stock exchange approves it, then those who have been disowned, they will be considered as public. But those processes will have to be followed.
If the conflict arises between the promoters, and since they hold more than 20% stake in the group company, can they appoint their nominee director on the board or not?
When there is a conflict.
Yeah, when there is a conflict between the promoter and
Yeah.
since they hold more than 20% stake in the group company, can they appoint their nominee director in the board or not? One question is coming in my mind: if the conflict is existing between, how can they compromise for coming to the appointing of the nominee director itself? Anyway, that is a thought.
Because ultimately the directors will be appointed by the shareholders. If the shareholders approve the appointment, then they
No,
get
that is right. But when he's talking a nominee director, they don't nominate somebody, na? Because
No,
they want to appoint their nominee director on the board.
No, but they can't just nominate. No, it has to be approved by the shareholders.
Yeah, correct. Sir, if this question is relevant, then please answer this question. I don't probably with reference to this. What are the special rights can exercise in the promoter shareholder? I think special rights we are going to discuss actually.
Yeah, correct.
Because the next slide is going to come on the special right. So wait for that. So we will discuss.
And Vansika Sharma has raised the hand. You want to speak, then just allow her to speak. IT department. Yeah, Vansika, you're there?
Yes, ma'am. I just had one question, ma'am. Please answer it whether if it is relevant or not. Are securities of private company not regulated by SEBI? And if they are, then whether the promoters regulation applicable to promoters of SEBI, promoters of private company as well, like whether the promoters regulation applicable to promoters of private company as well.
So your company is private company. So SEBI
Yes.
LODR regulation is not applicable, right? Now,
Yes.
what is your question?
So, ma'am, the promoters of the private company will be out of this regulations, right? These regulations won't be applicable to the promoters of private company, right?
Yeah.
Yeah, if you are not
Okay,
listed,
ma'am.
you are not a listed entity, it is not applicable.
LODR
Thank you, sir.
applicable
Because the LODR regulation applies only to the listed entities.
Okay.
If you are
Yeah.
not listed, you are out of it.
Yes, ma'am. Thank you so much.
Anamika has raised the hand.
Yes, Anamika. Earlier also raised the hand, but you did not speak. You need to unmute. I hope IT department is unmuted, Anamika.
Yeah. Anamika, you
Yeah,
can audible
now she is there. Yeah. Yes, Anamika, we can.
Yeah. Yes, sir, there is one entity of promoter group, and when the company had filed the shareholding pattern, the entity promoter group, the of course entity who is actually the in the promoter group, but wrongly mentioned the in shareholding pattern in public category. So how to rectify it? But actually he is the entity of promoter, but in shareholding pattern, the holding of that entity wrongly mentioned in public category of shareholding. So how to rectify it?
No, if it is just a kind of a mistake I mean, it's not intentional, and you can just say that by oversight it was put in that category, and then it has to be read as this. That's all.
Yes.
Okay, Miss, but there is one question, Mr. Bala from
One more question has come.
Ah,
If an individual from the promoter group sold his complete holding in the market and now his holding turned to zero, does the company need to reclassification or already remove his name from the promoter group in the shareholding pattern?
No, just because he has sold his shares doesn't mean that his thing will go away from the promoter group. In case it has to be reclassified, if he is not to be shown as promoter, then he has to follow all the conditions, even if it is a nil holding.
yeah, Miss Pratika is asking to allow the unmute. Yeah, IT department.
Yes, Pratika. Are you there?
Pratika?
Pratika, you can unmute and speak.
Yeah, yes.
हेलो
Yes, please.
ओके गुड आफ्टरनून एवरीवन सर मेरा एक सिंपल क्वेश्चन है हमारे वन ऑफ द प्रोमोटर इज एन डाइवोर्सी ठीक है तो हम लोगों को
Pratika, can I request you to just put in the chat box so we read and that reading time is speed.
यस ऑलरेडी आई हैव मेंशन इन द चैट बॉक्स में
Okay.
do we need to take letter from promoter for reclassification of share in case of divorce?
The application will have to be made in any case, even if it is a divorce. Then the application to the company, then board approval and application to stock exchange, everything will have to be done.
Okay.
Yeah,
So exemption is only with respect to the shareholders approval. Rest,
Correct,
the procedure will be same.
Yeah,
Okay.
otherwise the procedure is the same. Yes.
Yeah.
Pratik-
Okay. Thank you.
Pratika, as
Yeah.
Sridhar puts it, any reclassification, there should be a formal request as to come from the person seeking the reclassification.
Okay.
Then the question is whether it is, falling in the exemption category, whether it is a shareholder approval, etc. That will be examined.
Okay. If I don't know if this question will be relevant to you all or not. If that same promoter is not giving us the disclosure pursuant to regulation 31(4), in that case, the liability will be on the promoter, not on the company, right?
But efforts will
Early
have to be made
disclosures.
by the company to get the disclosures from the promoter. If in
Okay.
spite of that, the promoter doesn't disclose, then that is a different thing.
Okay. Yeah.
Yeah.
Thank you, sir.
Yeah.
Okay, I'll request participants that if your question is not answered, you can put in chat box your question is not answered. So we'll take it by mistake if it's skipped. Further, please note that whatever answer the panelist is giving is based on the limited information and understanding we have on the subject, because there are many factual circumstances people are asking the questions. So it has not necessarily that cover all the facts, because there are other facts pertaining to that situation. So it cannot be taken as final answer to that particular situation or question, because we have to correlate many things. So it is kind of understanding a general question. It cannot be taken as a final answer. We request that in case of particular situations, circumstances, you have to go back to the law, decided cases, and then you have to take a decision. I hope I am clarifying the situation from all the part, on the panelists. Okay, now Kinjal, you can go ahead.
Yeah, one more question is there. We'll finish on that. 31(3)(b) says that the promoter seeking the reclassification, the person related to the person seeking the reclassification should not be holding KMP position. Does it mean that neither the person seeking the classification nor his relative should be holding KMP position?
Correct. He cannot hold. Of course, it is not about the relative. It is actually, it's only the person seeking the reclassification should not be holding the position of KM.
Yeah, you're right, actually, because I think what the wording says is promoter seeking reclassification, person related to the person seeking. That means they are referring either the promoter or the promoter relative.
Yeah,
So that means the person who is seeking the reclassification should not hold the KMP position, whosoever
exactly.
it is.
Exactly.
Okay.
I think we can move to
Yeah, you can move to the
31B.
next one.
Yeah, Kinjal. Thanks everyone for your participation, active participation. We hope that we satisfied you all. Thanks. Yeah.
Regulation 31B, special rights to shareholders. Now, this is a new regulation which has been introduced in the month of July 2023. The regulation talks about the compliance requirement wherein there are special rights available to certain set of shareholders. In case if there are existing special rights given or granted, to the shareholders, then a special resolution is required to be passed within a period of 5 years from the date of coming into force of this regulation. If any special rights are to be granted to the shareholders of the listed entity, then special resolution approval will have to be taken, and such an approval will go for renewal. That is, special resolution to be passed once in every 5 years, starting from the date of grant of such a special right. There are exceptions given over here. So if there is a financial institution registered with or regulated by the RBI and under such a lending arrangement in the normal course of business, or by a debenture trustee registered with the board and under the subscription agreement for the debentures issued by the listed entity, if such financial institution or the debenture trustee becomes a shareholder, and as a consequence of such a lending arrangement or a subscription arrangement for the debentures, then the special resolution from the shareholders is not required.
I would like to seek expert views from my good friend Sridhar. Here, the special rights which are actually already available, the company has started, they enter the agreement, it has been there, and there are long-term investors who are actually there was having this arrangement. Now you say you take a approval from the shareholders and every 5 years you get it renewed. Now in the company, shareholders do not remain the same, they keep on changing it. Who were the shareholders 15 years back is not the same shareholder today. They are not going to be the same after 10 years. Now the company's history, etc., and other thing and all, nobody goes through once you take up the shareholders. Now, if the shareholder rights are actually approved in the first meeting, it comes for the renewal for the next 5 years. If the shareholder decide to disapprove, reject the special rights, what happens?
Yeah. So, that is a very valid point. And in fact, some of the investors, the large investors who have actually come into the company based on such special rights, I think they may be feeling let down by these provisions. At least they will feel that it should have been done only prospectively, not for the special rights which have been granted prior to the agreement, prior to the amendment. So in future, yes, one could say that, okay, every 5 years, if you provide for approvals, that every 5 years you have to go to the shareholders, that's perfectly fine. But if some large investors have gone for a special rights and then gone for some investments in the particular company, so they can justifiably be feeling let down by these provisions, and they could probably say that, okay, we'll let us have disclosures. We'll say that these are the special rights which have been given to such investors. Let it be disclosed, and the shareholders, the new set of shareholders who come in, because of course ultimately it's a constant flux of shareholders. So they will be having the disclosures in hand, and with the disclosures in front of them, they are actually going and buying the shares in that particular company. So that should be fine. So, but ultimately, I think SEBI has, in its own wisdom, has gone as per the consultation paper which was made in February 23. And then they have said that, of course, since there is a new set of shareholders, they deserve to go through those special rights once every 5 years, and they should approve it, etc. Yes, in a way, it is. I mean, intentions are good, but it may be to the detriment of some of the large investors, and sometimes detrimental to the interest of the company as well, because probably they have got certain shares from the large investors based on that understanding. So it is a little debatable point, but ultimately, as regulations have now been made, then of course once every 5 years you will have to go through the shareholders special resolution, and then there is of course a hanging sword which will be there, and then it may or may not get passed. But the large investors who have gone for the investment will have to just be hopeful that it will be approved, and then they'll have to continue. That is the only way, I think. So, of course, the representation can be made, but it's doubtful whether SEBI will really look at those representations, because they would say that it was already there in the consultation paper in February 23, and then the whatever representations have been made have all been considered, and in spite of that, they have come out with this recommendation saying that once every 5 years, even for the special rights already granted prior to the amendment, should also come before the shareholders once every 5 years. So once it is there, then I think nothing much can be done. But that is a position now. And then because the special rights, somebody also had asked what kind of special rights can be there. So it could be special rights with reference to nomination, with special rights with reference to anti-dilution, or it could be some special rights with regard to information rights or tag along rights, etc. So some of these special rights will have to be approved by the shareholders once every 5 years now, and the existing ones will have to be approved within 5 years from 23. So which means before 28, it will have to be approved by the shareholders.
Dipti and Atul, since you're all dealing with the many clients, any such things has come up, and any representation taken up with the SEBI, etc.? Any idea on this special rights?
These are all very unique cases, I mean, so we have not handled those kind of a complicated case, but yeah, so each one is a unique case. Of course, regulators try to cover, under the regulation, which is most difficult thing. You have a divorce, you also have a son, also adopted son. Some.
And again, we were also discussing that let's accept that the guidelines are not so clear. That's why I specifically declared also that each situation is different. We have to handle it. There is not much clarity. There are many things we have to interpret ourselves in the conservative way. In the interest of compliance and governance, we have to take it. And that's why there cannot be a yes-no kind of question for a particular situation. Each divorce, if you take it or like that way, also there are many things involved in that and which are factual. So each situation needs to be interpreted. We handle that, but honestly, Mr. Bala, it requires a lot of minute understanding and dissecting the facts. Then we take our call and give the reasoning why we are taking this decision. So it's not straightforward question. So we ourselves also. Ashwini, you would like to add on that, please? You are discussing the same thing. Ashwini?
Yes, ma'am.
Yeah, can you give comment?
So each case is different, as ma'am said. So we'll have to study the facts of the case and present accordingly. That is what we were discussing just now.
Yeah. So that's why, Mr. Bala, bluntly, we cannot say that, yeah, if this is the case, you have to do this way. It depends, and it's a kind of general case we can comment like this.
No, apart from the regulation, which is actually there, as Sridhar puts it very correctly, regulation is there, we'll have to adhere, we'll have to comply with it. There is no escape at all. I agree with that. There is nothing right or wrong. We have to go by what regulators say. That is absolutely right.
Yeah.
But purely in my personal view, what they could have done is the special rights which are already granted. They would have made the disclosure requirement.
Correct.
Because
Absolutely.
any regulation which is coming with the force should be prospective. It cannot be retrospective.
Yeah, exactly.
So in which case they should have said actually, what of the special rights already granted to the people is need to be disclosed to the shareholders. Any new special right you are going to grant, have the regulation to be followed. So the things are made known. The people who are already having a special right with a certain understanding, etc., who is a long-term investor, they are not, put in the situation that a sword is hanging on their head every 5 years. That is my purely a personal view. But the regulation is there. So since the regulation is there, we'll have to comply with it.
I fully agree with you, Bala. Correct.
Yeah, there is a question, Mr. Bala, special.
Yeah. There is a question is there.
Or shall we take now or Kinjal, there is a more, then we will take it later on.
No, this is regulation 31B. We can take the questions.
Yeah.
And move on to the other.
Yeah.
Public charitable trust having one of the promoters of the listed entity as a trustee. Can this trust be termed related to promoter group for the purpose of the computing 10% shareholding criteria condition to be followed if it wants to reclassify?
No, it cannot be because I think Kinjal has already mentioned as to what is the meaning of promoter related to the promoters. So it is already defined there. So this doesn't come into that.
Special rights are available to what type of the shareholder as the recognition holding the exercise special right? I think you discussed this.
Yeah, this we have discussed.
Yeah. That's all I think. You can go ahead.
Yes, sir. So regulation 32, the last regulation for today's webinar, statement of deviations and variations. Again, this is a compliance regulation which talks about the statement of deviations and statement of variations. Under regulation 32(1)(a) and 32(1)(b). Statement of deviations is with respect to the proceeds of the funds, the purpose for which the proceeds of the funds have been raised, and statement of variations is with respect to the various categories, say capital expenditure, working capital, the funds, how they have been categorized. So if there are variations in that, that statement has to be filed with the exchanges. Both of these statements are required to be put up to audit committee for review under regulation 32(3). Both of these statements will be filed with the stock exchanges within 45 days of the end of each quarter and 60 days from the end of the last quarter of the financial year. Statement of variations is also required to be reported in director's report. Now, earlier, before the SEBI circular of December 2019, there was no format and the companies used to report these statements in different formats. To streamline this whole thing, pursuant to the circular December 2019, the format has been prescribed and the statements have to be filed in that prescribed format with the exchanges. Annual statement for utilization of funds under regulation 32(5). This also needs to be put up for audit committee for review, and it has to be certified by the statutory auditor. There is monitoring agency report. Under the ICDR regulations, if the funds are more than 100 crores, the size of the funds, in that case, monitoring agency, that is a credit rating agency, has to be appointed. And such an agency's report has to be put up to audit committee for the review, and quarterly basis, it has to be filed with the exchanges. That is within 45 days of the end of the each quarter. Now, under regulation 32(2), statement of deviation or variation shall be continued to be reported till the time all the funds have been utilized for which the for the purpose for which the proceeds were raised. Under regulation 32(7)(a), the funds raised through preferential allotments or QIPs, the listed entity shall disclose every year the utilization of such funds in its annual reports till the funds have been utilized fully. And under regulation 32(8), for the SMA listed securities, these compliances will be considered on half-yearly basis. That's all from my side. Thank you. We can take the questions. This is the last slide of the webinar.
But one practical aspects maybe we can cover. While intimation, I mean, the review has to be made by the audit committee in all these 4 matters which Kinjal has mentioned. But whether the board also has to note it or not would be one practical issue which can come up. But some of the big companies, what they do is, whatever is reviewed by the audit committee is also placed before the board for noting. And the board also notes all those statement of deviations or statement of variations and the monitoring agencies report, etc. So it will be a good practice to place it before the board as well, because what our audit committee reviews, I think it will be a good practice to have the board also at least noted, if not reviewed by the board.
Okay.
I also would fully agree with you on this, because normally, as a good governance practices, all the subcommittees are actually formulated by the board. The committee, the activities, whatever is done is again reported back to the board. Even when we conduct the board meeting, normally the item of the agenda will be confirmed at the last board meeting and taking note of all the committee meeting which has been conducted during this quarter. That's the way we go about it. So naturally, in this case also, if the audit committee has reviewed, etc., okay, as per the regulations concerned, it is perfectly all right. There is no issue. But from the governance perspective, as you rightly said, it has to be put to the board. Board takes a note of it. So that is the right procedure. I think many people have been following that only in most of the companies, I believe. Yeah.
And of course, one point that can be noted is, of course, the SEBI continues to use the word director's report, while companies are maybe using the word board report. So, so it's not, there is no exact consistency in that, but of course, the meaning is the same. So ultimately, one can take it.
Always harmonization issues are there between the Companies Act and the SEBI regulations. That is continued to be there. But anyway, as you rightly say, so long as we are referring the LODR regulation, we'll have to go by the wording which is put in the LODR regulation. When we use the Companies Act, we go by the company. But however, if you refer the annual statements, the report is actually mentioning the board report only. It is not mentioning the director's report. That is better, because the director report has been dispensed with the long away. It continues to be a board report only today in practical. That is the thing.
Correct.
One question has come.
Let me see here. Auditor certificate is needed when?
So that is, of course, at the time of the annual statement. No? That is when the annual statement is prepared about the funds utilized for purposes other than that, then it has to be certified by the statutory auditor. So it has to be at the time of finalization of accounts. So along with the accounts, along with the board report approval, etc., April, May, whatever practice is followed by the company. So that will have to be, the auditor certificate also has to be obtained by that period.
Is it applicable only when it's 100 crores, right?
Yeah.
Yeah.
I think they have mentioned,
I think that is all the questions. I think I don't have anything in the chat box. The question is there. And Kinjal, you have
if
prepared
anyone wants to ask the question, then unmute or raise the hand. Otherwise, we'll close the session.
Yeah, in the meantime, I would like to convey my great appreciation to the Kinjal and putting the regulations put together very precisely and bringing out with the latest amendments and adding our own value addition, etc. She has done a excellently a good job. Of course, my good old friends, any amount of the appreciations we can give him, because he is the largest serving company secretary professional in the field, especially with the renowned listed group of companies. And not only the company secretary, but also a what we call chartered accountant, and there is enormous knowledge. We definitely get your benefit in giving the practical view on the good corporate governance practices. Many thanks to you. I personally continue to learn in every seminar something or other new. That is, I have a great pleasure to you. Dipti, over to you.
Yeah,
And I must also just thank Bala, Kinjal, and Atul Bhai and Dipti for the opportunity provided to me. I really enjoy. It's been, as Bala said, it's a real learning experience. As we discuss more and more, I think a lot of brainstorming takes place, a lot of new ideas come up, new points come up. So thanks a lot for the opportunity. Thank you so much.
thank you,
So,
thank
yeah, a request to all of you to subscribe to the channel because this video will be uploaded to our YouTube channel. So yeah, so you are not missing out on anything. In case if you missed any of the program, you can always go to our YouTube channel and see those. So thank you, Sridhar ji. I met you last week. It was a pleasure meeting you, and good to see you in our platform. And we look forward to see you again and again. Companies Act is still evolving, after 2013 Act, and even LODR, since it has been introduced after 2015. So every day is a new day, and SEBI makes sure that all the compliance officers are on their toes by amending various regulations, left and right. And yeah, because we are living in a world of not on an email but WhatsApp, so things change very fast. So thank you, Mr. Bala, Sridhar ji, and all my team member, and a special thanks to Kinjal for a wonderful presentation, very crisp presentations. And we missed Mr. Sudhakar today, but definitely he will be there tomorrow. So thank you all being a part of this journey.
Yeah.
Thank you. Yeah, Dipti, you
Thanks
want to-
everyone for participation, and your participation and your questions only make it interesting, and it actually give insightfulness to us and all the participants. Thanks for that. The third people has asked YouTube channel, then we have mentioned that it is Decoding the Corporate Laws with Mehta and Mehta. This is our YouTube channel. You can subscribe the same. That will be helpful. Thanks participants, keep on doing that. Thank you, Sridharji. Thanks a lot for your all experience. Thank you, Kinjal. Thank you, everyone.
Thank you, everyone. Thank you.
Thank you.
Thank you to all. Have a good weekend.
Yeah.
Yeah.
Again, we keep meeting again and again. Thanks a lot.
Yeah.
Thank you. Thank you.